If the court pleases, my name is Alexandar Argyropoulos, and I appear on behalf of the Director of Public Prosecutions. On the 6th of August 2020, Danny Jones, an inmate at Barwon State Prison, stabbed Jack Smythe, a fellow inmate, using a makeshift weapon personally constructed earlier. The assault was unprovoked, with Mr. Jones attacking Mr. Smythe on account of his quiet nature and unwillingness to participate in various recreational activities. Due to the stabbing, Mr. Smythe has suffered serious lacerations to his chest and was placed in an induced coma for several days. Mr. Jones was charged and subsequently pled guilty to intentionally causing serious injury as per Section 16 of the Crimes Act 1958. Aside from the near-fatal injuries incurred, Mr. Smythe has been left traumatized by this incident, to the extent where he is reluctant to traverse outside of his cell and was hesitant to identify his assailant. An important justification for offenders serving prison sentences is to reduce recidivism and reintegrate them into society. This purpose is undermined and hindered if those in prison live in imminent fear of unprovoked violence. Given the severity of the attack, Mr. Jones should be given a custodial sentence of imprisonment. This is for several reasons. As per Section 5(1) of the Sentencing Act 1991, just punishment warrants such a sentence due to the intentionality and seriousness of the injuries caused. Similarly, an emphasis on a denunciation of Mr. Jones's actions is paramount, given they undermine any potential rehabilitative and protective purposes that prison may serve. Such a denunciation and sentence shall also serve as a general deterrence to potential offenders, stating that violence against inmates is not to be tolerated. It is acknowledged that further time in prison is unlikely to serve any specific deterrence or rehabilitative purpose, given Mr. Jones's distrust of authority and unsuccessful participation in an anger management program. Nevertheless, the necessity for the protection of the community, given Mr. Jones's history of violence and the unprovoked nature of the assault, is paramount above all else. Regarding Section 5(2) of the Sentencing Act 1991, current sentencing practices, the nature of the offence, and the offender's culpability must be considered in determining the appropriate sentence. From 2016 to 21, 85.5% of sentences involving this offence were sentenced to imprisonment. The average sentence length for the year of 2020 to 21 was 7 years and 3 months, with a non-parole period of 4 years, 8 months. The maximum penalty permissible is 20 years imprisonment. It is acknowledged the difficult circumstances that Mr. Jones has experienced in his life that has made his offending more likely. Furthermore, another mitigating factor in Mr. Jones's favour is his immediate pleading of guilty, suggesting an acknowledgement of his culpability in this serious offence. Conversely, Mr. Jones's attendance at an anger management program only 1 day before his offending suggests he harbours no serious intention to rehabilitate. Moreover, the unprovoked and life-threatening nature of the attack warrants no sympathy, and it can be regarded as an aggravating factor in considering his sentence. Whilst much of his criminal record does not pertain to this offence, he has been convicted of several minor assaults and was imprisoned originally for assaulting a police officer. His penchant for it is clear he has a penchant for violence, and this serves as a further aggravating factor in this sentence. Considering both the mitigating and aggravating circumstances of the case, whilst the maximum sentence for this offence would be excessive, a sentence above the average sentence given for this offence is necessary. Given current sentencing practices and the particular severity of this offence, any other method of justice, such as a community corrections order, would be inadequate and fail to achieve the purposes for which this sentence is being imposed. As such, in keeping with a sentence that is both proportional and parsimonious with the offence, the prosecution will be strongly recommending a sentence of 8 years and 6 months prison, with, subject to his continuing good behaviour, a period of 5 years non-parole.